Good afternoon, everyone. Thank you for joining us to this panel on It's Time to Forget, Metadata and Digital Memory. And we are delighted to have you with us today. Advocate Sharon Azarya. She is the head of the International Department in the Israeli Privacy Protection Authority. Orna Heilinger, who established the Internet Security Center of the Israel Internet Association, ISOC-IL, building and operating an emergency line to support people who are victims of the Internet. And Paula Kiel. Paula is a PhD candidate in the Department of Media and Communications at the London School of Economics and Political Science. Her PhD project explores contemporary mediations of death within Western societies through the study of services offering to enable post-mortem online communication. Her paper, The Emerging Practices of the Collective Afterlife, Multi-Model Analysis of Websites for Post-Mortem Digital Interaction, won the Best Student Paper Award in 2017. Sharon?
Okay, so hello everyone. We'll start this panel with the right to be forgotten, or the right to erasure, as it's actually called in the new GDPR. Okay, so some of you here in this room still belong to the age, like me, that people used to say that today's news are tomorrow's fish wrap. So, but unfortunately, today's new outlets cannot serve anymore as fish wraps. And unfortunately, or fortunately, it depends which point of view you present, the digital memory is endless. You know, our memory sort of like is limited, and we forget, naturally we forget, but when we're in the cyberspace, it's unlimited, of course, and things that we've done 20 years ago may pop up and won't give us a rest. When the digital rights community started talking about digital memory, poor Stacy Snyder always comes to my mind. I've encountered this picture in a lecture maybe 10 years ago. Poor Stacy was a student for education in the Maiersdorf University. And poor Stacy went to a party and she had a drink, and she dressed up like a pirate, and she put this photo on MySpace. And a few days before she was actually supposed to graduate, she was learning education, she was supposed to be a teacher. The management of the university called her and told her that she will not be graduating school because she's not a role model for, you know, an educational figure. So this case always represents the big problem of the digital eternity, we'll call it. So the question is now, how do we tackle or fix this problem of this endless memory? Kostecha actually started, doing the job for us. I don't know, probably some of you know Kostecha. Mario Kostecha was a Spanish lawyer. And when he put his name in Google, it popped up some advertisements about real estate that he had maybe 10 or 15 years ago, which were put on sale because he went bankrupt. So Kostecha was really angry about the fact that anyone who puts his name in Google knows that he went bankrupt 15 years ago. I mean, he's not bankrupt anymore. This information is not really relevant anymore, but it still pops up. Now, we have actually two service providers that are actually responsible for this. One is, of course, the people who put on the ad or the website that has this ad, and Google. Now, the problem with Google is that Google is actually the gateway to the internet. So whenever we put our name, or when we conduct a search by a name, first of all, Google increases the amount or the effect of the publication, because it's not only the website, it's Google. And also, you don't go to the website, you go to Google. So much more people will be exposed to this kind of publication. But also, when we search by name, a lot of information comes. It's not just one news article. You can have your whole life on Google. So the question was, is there a right to be forgotten? Because Kostecha wanted Google to delete the links that linked to the article from Google. Okay, and this was actually what this case was all about. So actually the court ordered Google to delete the links that linked to the original publication. And it set up some criteria according to which links should be deleted. So the court actually checked whether the information is relevant, or if the information is no longer relevant, because it is relevant when a person is bankrupt, especially if it's an attorney, but is it relevant that he was bankrupt 15 years ago? Probably not. Also excessive, if the information is too excessive, and so maybe it's another consideration to erase the link. And so if the information is adequate or accurate. Inaccurate information will have a tendency to maybe delete the link. Okay, so actually what we can say about Kostecha, because Kostecha really rocked the boat with regards to digital memory and digital rights. And you know, the people in the community, in the digital community, everyone knows who Kostecha is. So all Kostecha wanted to do was to actually be forgotten, but now millions of people know that Kostecha went bankrupt. But the decision still raises difficulties. Now, I'll just have to limit the scope, because sometimes when people talk about the right to be forgotten in the Kostecha case, they think that, you know, you can delete everything and every outlet. So we should be attentive to the fact that the decision applies only on the search results which were produced by inserting a name. And again, it only deletes the link to the content. It doesn't, the Kostecha decision didn't order the content, the website to delete the news item. So you can still find this article or the advertising in other ways, but not by searching Kostecha through Google. So, but of course, the decision raises questions with regards to privacy versus freedom of speech and freedom of information, because we use search engines. Search engines are our gateway to the web. So when we delete links, we reduce the content and we reduce the public accessibility to information. Another concern is that this decision would be a chilling effect on freedom of information with regards to search engines, because, you know, if I'm Google and I have to put all my workers to decide if they should delete the link or not, and then you say, okay, if I don't delete the link, then I'll be subject to lawsuits. So maybe I should just, you know, delete every link that I'm asked to delete, and you know, I'll be the censor of the internet. Everyone who's not happy with everything that was put online, then, you know, I'll just delete it. And another question is, how are DPAs? Okay, what I didn't say about Kostecha is that the court said that, you know, search engines should do the balance of the considerations that we've talked about. And if the data subject that asked for the deletion of the link is not content, he should go to the DPA, the Data Protection Authority, or the competent authority in his jurisdiction. So now what I should also say is that this decision applies to residents of the EU. So the question is, how are the DPAs that now receive applications from data subjects whose search engines denied their request to delete the link to content about them, how are DPAs supposed to decide when a link should be removed? So the Working Party 29 actually issued guidelines with regard to this question. Working Party 29, for those of you who are not familiar, is a body, an advisory body that advises to the EU and DPAs how to apply data protection laws. So they've issued guidelines. And they actually, you can learn a lot about the guidelines, from the guidelines, and they actually make a nice balance between the right for privacy and the right to freedom of speech and the right to access to data. So these are the following guidelines. First of all, when a data subject wishes a link to be deleted from a search engine, then he should apply to the search engine, send the link of the content, and also indicate if they hold a public position, because public position figures are more exposed. Their lives are supposed to be more exposed, and also there's more public interest in data about them. So this is the only two. This is the information that you have to supply in order for your request to be processed. Another question that arose was, should a search engine put a disclaimer near the search results? For example, if you put the name of a data subject, and can we receive a decision saying, or a notification saying that the links were deleted? So the Working Party 29 said no, because this will actually, focus more information, more attention to it, and people will start to wonder what's going on. So you can have like a general a disclaimer on your website, but not a disclaimer that is for a specific query. So this is very important. Do they have to give a notice to the original content about the deletion? You're deleting a link to a website, to a page in a website. Should you notify the website? So the Working Party says, no, you don't. You can contact them if you want to consult with them. But no. Okay, I see that I only have 3 minutes left. Oh my God. Okay, so we'll try to run through this. Okay, another thing is the age of the data subject. Minors will tend to delete the links. Is the content an opinion or facts? If it's an opinion, then it's more of like a journalistic or freedom of expression, and freedom of expression will prevail. The age of the data, the more the older the content is, it will probably be deleted. If the data relates to professional life or private life, is the data sensitive? Did the data subject consent to the publication, and afterwards he withdrew his consent, because consent is a very fundamental principle in privacy. So is it in a journalistic context? If it's a journalistic context, then maybe freedom of speech will prevail, and so on. A few years later, we received the GDPR. GDPR, for those of you who are not familiar with, are the new laws, the EU laws for privacy protection, for data protection. And they have a new right, which is much broader than the right in the Kostecha case, because again, the Kostecha case is limited to links that refer you to other articles. So there's a general right now to be deleted in the EU. Okay, from any database, whether it's a closed database or whether it's a public information that is available for the public. So first of all, there is a right to be deleted or to be forgotten. And these are all the considerations that will support the decision to delete the data. Of course, to every rule there is an exception, so there are some exceptions according to which data will not be deleted, although the data subject requested its deletion. You'd ask me about Israel. That's a touchy subject. Does the right to be forgotten apply in the Israeli legal system? So I would say yes and no. The only specific case that is indicated in our privacy protection law is the direct marketing. When you have those marketing lists, then the law says that upon a request of a data subject, the direct marketer must delete the name of the data subject. We think that you can define the law in order to sometimes oblige data controllers to delete data. For example, as I said, usually in privacy protection laws, fundamental principles are consent. Usually you need the data subject consent to process their data. So if the data subject gave their consent and it was given usually in the context of a certain purpose, then if the data is used for another purpose, then it should be deleted. So the data should only be kept when it serves the purpose for which it was collected in the first place. So this is one consideration that would support deletion of data. Data minimization, we have data minimization in our new data security regulations. And according to the regulations, in order to avoid breaches and in order to breaches of the data, you should only keep minimal data in your databases. You have an obligation to minimize the data. So we could maybe say that the right for deletion derives from this obligation. But all of those interpretations of ours never were considered in court yet. So, time will tell. We can say that the Ministry of Justice is making a list now. We're comparing our Privacy Act to the GDPR. And one of the issues that are on the table are, of course, the right to be forgotten, but we don't know yet if this is one of the changes that will be made to our act. So thank you.
And I'm not a lawyer, and I'm not coming from the university and everything. My daily routine is to talk to people who something happened to them in the web. Big part of the calls that we are getting are concerning the right to be forgotten. And I want to give you a story from last week. Yuval Mevulbal. For the English speakers, he's an actor in Israel, very popular with children. And we woke up one day last week to notice that this Yuval Mevulbal, which is a role model for the kids, questioning about using drugs. And the question is whether is it the right the public to know or his right to privacy. Let's just to open a dispute about this. Let's go on. What I'm saying is it's not always one versus the other. I think the basic rule is that there are times which the public right to know is stronger than the right to be forgotten, and there are times which there is no question about it. Like, so I Googled myself this morning. And I found many remarks, and there are two which are so irrelevant. Like we as a family had a law issue between Tiv-Tam, a company in Israel, and us. What it gives to someone who Googled me to know that a few years ago we had a law issue, or even something nicer. 28 years ago, I published a book, a novel. Now it's nothing to do with me as Orna today, which it doesn't really need to be there. But these are examples of mine. Let's say this man smoked a pipe. Is it really important to all the others to know that he 10 years ago smoked a pipe, or the car accident? Which this picture, which I took from the internet, is forever. Some other examples are those who decided to publish their kids online. Michelle Reitman and her brother, or Super Nanny. Super Nanny was if you all remember, that bring a camera inside the house which took pictures of the family, which are other adults and also children. And now nobody asked those children if it's okay with them. Nobody asked and explained. They explained to them. They don't really have the ability to understand the meaning of this picture 10, 15 years ahead, what it might do to them. Some more example, just before I'm going to this example. By weekly, every week we have an issue that a teenager or a parent to teenager called us and said, when he was young, he did this and this and this. When he was young, we did this and this and this, and now we cannot stop it. His friends are watching this videotape in YouTube, in other places, and it's impossible to erase or delete. If I'm talking about children, there is no reason why those remarks should be not deleted.
רציתי לשאול, מקודם הילד הזה שראינו שם, איך קוראים לו?
סן.
סן, ואת חברה שלו?
כן.
והוא חמוד? אבל כאילו את מאוהבת בו או לא ממש?
לא מאוהבת בו בכלל, אבל חברה שלו. אבל בתומר ממש מאוהבת. אפילו אי אפשר לפוצץ את העיניים. אפשר רק לשמוח מתומר.
שנייה,
אני מאוהבת מתומר.
תומר הוא חתיך?
חתיך גבר שאי אפשר להרוס את העיניים. אפשר רק לנצנץ בעיניים.
מה, הוא מטריף?
מטריף את החושים.
מטריף את החושים?
ממש.
כאילו אין דברים כאלה.
חטיף.
הוא ממש חטיף.
And it goes on and on and on. She's going to get married with all the boys in her classroom. And yet, this is a great example for a parent, her father for this matter, take a picture of his daughter, which is obviously, in a few years, she's gonna be upset, very upset, to meet herself in that way. And I'm telling you now, in 10 years from now, nothing can be done. Nothing can be done. So this is another example. And for at the end of my words, we give up our privacy in many ways. In many ways, even in ways. But is it really wrong to accept that my credit card won't keep my shopping list for years? Is it too much to ask that my metadata will be mine to decide whenever it doesn't important to the public to know? It's me to decide whether I want to keep it or not.
So I'm going to start with saying that that this presentation and my research is very different to everything that has happened here today, quite outside the discourse of rights and regulation, but nonetheless I think could offer an interesting contribution to thinking about and talking about the relationship between technology, social practice, and regulation, and how technologies and some technology use challenges some of the most fundamental social categories that we are used to working with. And also specifically, I think it will link interestingly to the two presentations that we just heard about the right to be forgotten and whether it's the right to be forgotten or the right to control how you are remembered. So I'm going to start with, first I'll read. So I'm going to start with drama. It's a story. The email arrives in my inbox like an unexploded bomb. Maria Weston wants to be friends on Facebook. Instinctively, I slam the laptop shut. Perhaps I was mistaken. I must have been mistaken because this cannot possibly be happening. Slowly, I raise the lid of my laptop. Hands shaking, I go back into the email, and this time there is no denying the bold fact of it. Maria Weston wants to be friends with me. But Maria Weston has been dead for more than 25 years. So this is taken from this thriller, Friend Request, written by Laura Marshall, but we are very familiar with this narrative, right? There are many popular texts that deal with this, that provide different versions of this ghost in the machine and how communication technologies and contemporary communication technologies can enable us to communicate with the dead and to communicate from beyond the grave. But what is actually interesting is first to remember how all these fantasies and these anxieties actually are. And I'm not going to go into depth about this because I probably don't have time. But each new technology for communication that emerges challenges our experience of being present and absent. And this is because each technology enables us new ways to be present while absent. It, in fact, separates presence from, it enables co-presence without physical proximity. So photography enabled my likeness to be present without my body to actually be present. And the telegraph enabled my mind to be present and receive instant input from two distant minds without the bodies actually being at the same time, at the same place and the same time. And so with each new technology that appears, and especially electronic media, trigger new fantasies and new anxieties about communicating with the dead and using the technology of the time to communicate with the dead and to communicate from the grave. So I'm not going to go into the historical examples. This is me when I was 4, but I'm not going to go into why it's interesting. Maybe I'll just say a few words about the telegraph and why it's a really interesting and relevant example. So the telegraph was first used in 1844, and it was the first time that you could actually have instant communication at a distance. So you could be connected with the mind of someone who was completely absent. And this very technology and the scientific discourse surrounding the telegraph was inspiration for many scientists to try to create a celestial telegraph that would enable you to call the dead and to communicate with the dead. So it's the same fantasies of if we just have the right technology and if we just have the right science, we will be able to communicate with the dead. And of course, digital media make no exception, and we see in recent years there are many practices related to death in which digital technologies are incorporated. But also digital media enabled us new ways to be present while absent. So right now I'm sitting here and someone is commenting on my Facebook, and someone is texting me, and someone is sending me an email, but I'm not there. So we already have this much more extended experience of practically continuous absent presence. We're constantly absent while sometimes being constantly present while sometimes being completely absent, which again brings out these connotations of death and of ghosts in the machine. And with recent practices of death online, death-related practices online, we also see that we are very much intrigued and occupied with these fantasies and anxieties, and this really occupies the popular imagination. And this is not only seen in popular texts, such as we see television shows like Black Mirror and movies like Transcendence, and different narratives of how we could achieve digital resurrection, or how dead people could be sending us friend requests on Facebook from beyond the grave. And part of this popular imagination are also individual users and also technology developers. And these is what is happening today online. And within what is happening online, there are the services that I'm studying, which are services that are which I define them as transcendence services, which are services that arguably enable individuals to control how they're going to be remembered and how to manage their online presence after their death. So these are examples of a few websites. I'm going to talk about them, but I'm going to present briefly the typology of websites. So these websites that I'm studying are not websites for memorialization, right? These are websites where someone says, oh, I have lots of things happening online and I want to be the one to decide what happens to them. Or I have so many friends and I have so much I want to tell them and I want to make sure that even if I die today, I don't leave anything unsaid. So I can use these services to make sure that I'm still present and I say all these things even after I die. So the first category of websites is what I call websites for administrative closure, and these are the websites that are about managing your digital and online assets. So who gets my Facebook account? Do I delete my Twitter account? Where's the password for my PayPal account, etc. The second category is of social closure, which is the kind of the goodbye messages. This tell your loved one one last time that you love them, reveal your secret, tell someone that you hate them, this final legacy and kind of having control of how you're going to be remembered and what is your message to the world. And then the third category is one of ongoing communication, and it's this fantasy of continuation and forever being there. So it's either services that enable you to create a video or text or different kind of messages to be sent up to 50, 80 years after your death. So you could, for instance, send birthday messages to a friend and make sure that those are sent every year up to 50 years after you died. Or services that use artificial intelligence with the aim of creating a digital avatar that will be able to interact on your behalf at some point in the future. So I have a few examples. Maybe let's focus on, well, this one is actually an Israeli website, Safe Beyond, and I think Paula mentioned it today. And this is a website that actually enables you to create different types of messages and send them well into the future after your death. And this one is very interesting, a Turnine, which enables, it's kind of a social network. So you have a counterpart, so it's the digital version of you. So while you're alive, this counterpart should keep on interacting on this social network while you're asleep. But then when you're dead, it will continue to interact on your behalf. And as long as you use it, the more you use it and the more information you give it, the better it will represent the likeness of you. So these are some examples. I would have shown a few. Well, if we have time, I can show a few videos because it's really interesting. But I said that they are arguably enabling individuals to control how they're remembered because, in fact, we know that this idea that digital data will remain forever, which of course part of this promise, is not always true. And specifically with these websites, many of them are no longer active. So you have the case of websites such as Eternal Thoughts or Live Forever or Intellitar and all these, big words of things that will be there forever, and then you go and then website no longer active. And so the first challenge is actually it's the practicality of how can they really make this promise to users, either because the website might no longer be active, or because if I leave messages to be sent to my son when he's 80, and which will be in the year 2093, I calculated this at home. And he might not have the same email address. So how can they really promise me that this control of my legacy will actually be delivered? And then the other question is how and should and how can these websites be regulated? Because there is no way for the customers to make sure that they ever get the service that they're paying for, that things actually happen the way they wanted them. And more generally, it's how these websites negotiate the social construction of death in contemporary societies. Because one of the biggest challenges, and we kept talking today about right to be forgotten or controlling how to be remembered, but the fact is that not many users are eager to use these websites. So these websites say, come, you decide. You tell us what to do with your Facebook. You say what you want to say. But then no one wants to do that. And even people who sign up to these services, they sign up, maybe even pay, but then they leave their accounts empty and they don't do anything. And this is becoming a problem of greater significance as more and more users of online accounts and online technology die and leave their digital remains online. So I think I'll leave us with the questions and the challenges, and thank you.
Okay, thank you, Paula, for giving us a glimpse to the future, or perhaps the infinite time of the digital age. And now we will open the floor for questions and further discussions. I think Maybe I'll group the question into 3 or 4 at a time.
Thank you. So I wanted to ask, first of all, I think that what was a bit missing is the reason why we care so much about, or I think first of all that there is a difference between, I don't remember what exactly was Paula's definition of controlling how you'll be remembered, I think is different from the right to erasure. And the reasons are very different. One is for living people, and the reason why they want to erase things is because it affects their lives now and not about how they will be remembered. And what I think is missing is the discussion of why we need this. Why would we want to erase things? So we could say, okay, there is this idea that maybe for children, obviously, as Orna said, obviously they would have, they should have some control over what kind of legacy they have, or what comes up in their searches when they are adults already. But the big question, I think, the harder one, is what to do with adults. And that's where it starts from, because Techa is not a child. He's an adult who's demanding, who wants this ability to erase a part of his past. And I think that what needs to be discussed is whether or not we actually want this as a right. And if so, then what is missing is the ethical justification for it. I think we could present one. I would say that we could say that to be a person means that you can change. And I think that's how we see ourselves. We want to be able to change. And if we do not realize the effects of digital memory, then we'll find ourselves unable to change. Because we'll find ourselves 20 years, now it's not so bad. It's only going to get worse and worse. Where we'll find ourselves looking up our information and not being able to do anything new, because people will say, no, you're not, you cannot change. You are who you were before. You are who you were a week ago, and you are who you were 10 years ago, and there's no difference. Nowadays, we'd like to say, I think, that there is a difference. So I think that's a part of discussion that I'd be happy to hear more from you about.
My name is Tal. I teach at Azarya Academic College, and I also study digital death, and I also teach media ethics. So I have a few comments, and maybe it's not really questions, more of comments. So about what Orna described, most of the examples that you gave are of mass media, not digital media, not necessarily digital media. However, we live in an age of user-generated content, so most of us, in a way, can arguably perform as media outlets, and therefore maybe we need also to adopt some kinds of ethic codes that are already out there for other media outlets, like newspapers, like journalists, and like television channels, because most of the examples that you provided are some things that are related to things that are already been discussed and established as ethical or not by other media outlets. And just kind of a provocative comment on this issue, and this is something that I also struggled with when I discussed the presentation or the display of images of dead people. If we think that it's not okay to show that girl's short video clip, why is it okay to show it here in a conference? So that's just a provocative question. And I think something that kind of relates to all our presentation is our right to manage our identity online. And this is something that is considered to be a right as we are alive, and the question remains whether this is something that that we can take with us to the grave, whether we can still manage our privacy post-mortem. And The last comment will be about the fragility of data. We started with this in the morning with the Anat's paper about how fragile is digital data, and Paula's examples are also so telling that even if we have some information that we deliberately send to online websites in order for them to keep them, we can never guarantee that it will still be there a few years later.
Okay, thank you. I have a couple of questions to Paula, but maybe one angle could be also relevant to the others. Okay, so I'm a lawyer. Okay, that's full disclosure. So we do have these sort of issues about what to do with carrying out of testaments. Okay, so in a way, this is not a new issue. How do you verify that when someone wants to when there are all these famous examples? Do you want to you want your cat to inherit all your property, etc., etc. So I'm wondering what's really different here, and I tend to think that what's different here, and I would like to hear your thought about this, is that we seem to understand, or we may be able to understand the continued existence online as a form of existence. So it's not just carrying out the wishes of the dead person, but also in a way extending the lifespan of the person. So as a lawyer, the question is, what is this extension? Is this the same person? Because in legal terms, the person is dead. Or should we be thinking about this extension as either as a new person with a separate existence, or as a sort of a shadow existence of the... Now, we do have in law, of course, institutions such as corporations that do not have physical existence. They are created by persons, and yet we give them legal rights and legal obligations. In some countries, they could be also criminally prosecuted. There certainly can be taxed. So the question whether you would consider your research agenda, what position would it take on the issue of legal personality of individuals post-mortem? Now, in what way is it relevant to the others? If we are inclined to recognize a digital person or an online person or an e-person, there are different names in the literature to this creature. This also affects the question of control over information for living persons. Because if I have a digital persona, which is different from my real persona, maybe it's another carrier of rights and obligations. And maybe on the right to erasure, the right to be erased, maybe we could also deduce from this a right not to be erased. Because when you are being erased, that's a death sentence for the e-person. So the question is to what extent are you open to these sort of legal conceptualization of a social reality or virtual reality?
Okay, so we start with the first question regarding the justification to control our information and change it. Orna, would you like to?
First of all, I would like to reply. I agree. This video should not be shown, although when I show this video and there are parents on the audience, I know for sure that they are not going to do the same thing. Also, it always the way which is the trade-off, and I agree with you. Basically, we agree about kids. We agree about youngsters. I think the right to be forgotten for us as an adults is also something that is not black and white, but though there are many things which are not relevant to others, then they should be forgotten. I will take the Sharon's example, the student, which is lost her opportunity to work because she did something very very trivially, and posted on the web. And this is something I believe that in a few years we ourselves regulate ourselves. First of all, what we put on the web, and secondly, how we appreciate it. But nowadays, there are a necessity for us to control ourselves, to control the data for ourselves.
So referring to
Yuval's question. Thank you. I think they're really interesting. I am not a lawyer, so I will answer the best I can. Thankfully, I recently read Tal's report, so that's been helpful. But maybe he would be able to also elaborate on this. But I want to start with saying that this actually links. Whenever I tell people about my research, they say, that's so creepy. Mm-hmm. And the reason why people think it's creepy is exactly because part of our personality exists through our online communication. It's not that we perform, it's not that our interaction, our communication is represented through those websites. It's that's where it happens. That's where that part of our personality exists. And also in interviews with bereaved individuals, people many times said that, for instance, a bereaved mother who has lost her daughter and then her Facebook profile was deleted, said it was like losing her all over again because this was part of who she was. So I think that there is definitely, and in a paper by Msimi et al., they write about the idea of distributed personhood and how parts of our personality are actually constructed through our existence through these different platforms. So there's definitely parts of our identity there. And yeah, that was my first question. Now, regarding whether they have a right and what kind of the legal framework, I would be happy to hear Tal's comments on this. But I think it is also that these websites, what they do, and when we write first, when someone writes a message or it's about managing your personality or your it's about having a right. I think I think it's a Jewish principle of the honor of the dead person and having a right to keep your reputation even after your death. So I think that might link to that. And also what these services do, they offer a service to living people. So it's executed after they die, but the right belongs to the living person who asked to have these messages delivered.
But do we have control on it? I mean, you mentioned AI that they're gonna track your kind of personality, and then they're gonna send them each day gonna send the message after we die. So do we still?
I think AI is very different, and if you go into transhumanist discourse and people who really believe that in a few years we'll be able, because at the moment it's not really happening, but people who really believe that in a few years we will be able to upload our minds and create these cognitive machines, then there are huge ethical questions regarding their rights. And would it be okay to turn off the computer if they're thinking and if they're writing, if they're creating these emotions and these texts? Then do what? But that's a whole. I think once artificial intelligence is involved, is a different set of questions regarding.
Yeah. Okay. Thank you. Any
thoughts on
this?
Hi. Question for Sharon and then a question for Paula. When we talk about the right to be forgotten, the word right goes to the basics of our social discourse, and I can understand, in modern society, the right to be forgotten is mostly in the context of absolution. Your criminal record is expunged. I cannot find normally another place where you have the right to be forgotten, especially in the law of verdicts. We still use the names of the people which were involved 70 and 80 years ago, and I find it difficult. Even in Kostecha, at the end of the day, it was about absolution because he wanted to find a job and there were problems. are there any other rationales for the right to be forgotten which do not revolve around absolution? And the question for Paula is, I think artificial intelligence, it's really nice. It's a nice term, but at the end of the day, it's a statistical machine which knows how to mimic me. It's really good at mimicking me because I'm not that complex as I would like to think, but that's all it is. And in that aspect, aren't we giving too much consideration? I'm going in the opposite of Yuval. Are we giving too much consideration for just mechanical knickknacks? I'm not really sure. We're not just creating too much of a hype really too early. When we'll be able to upload our consciousness, maybe, I don't know, but I would like to hear your opinion on that. So thank you.
Hi, it's more of a comment. I think that the whole topic that Paula just talked about is wonderfully creepy in a way. I mean, it's crazy. And perhaps we should also think about the right not to be hunted by our loved ones after they die. I mean, it's part of the something like that. I mean, part of getting over someone that death is, letting go of some parts of this memory. And I think there is something really interesting about the fact that someone or something takes control over the shaping of the memory of those who are still living. So it's just another angle that I would love your opinion on.
So I would like to start by saying that in our world there are no absolute rights, especially when we talk about constitutional rights, when we talk about freedom of speech and freedom of information versus the right to privacy, which is also a constitutional right in Israel and in Europe. And also a person has, a right for their reputation. Okay, so these are all conflicting interests. And what we used to do in the real world before we entered the digital age, we always balanced the interests. And now that we have the internal memory, it sort of like rocked the boat and shifted the balances because all this information is out there and it's not going anywhere. So we can use old mechanisms and we saw it in the Kostecha decision and also in the guidelines and the GDPR, journalistic interests and freedom of speech, our public interest versus privacy. So we always have to do those checks and balances. Now we should remember that in the old world, the information went away, was destroyed or was archived somewhere. The memory was limited. The ability to access all this information by a click of a mouse was not existent. So there is no absolute right to be forgotten, and I think I've shown it through the Kostecha decision and through the guidelines of the Working Party 29 and through the GDPR. But yes, one stupid mistake that we've done 20 years ago, should it taunt us and destroy our lives for 20 years? So all those checks and balances can give us the right or just solution. There are no just solutions. And if we want to talk about technicalities, the GDPR has this provision regarding information that was transferred, because in the internet, we copy and we transfer the information. So maybe I published the information, but it went out to 30 websites. So according to the GDPR, a controller that put out the information and was asked to delete it should take reasonable measures to notify other controllers as well that they should delete the message. So even when you have this right to be forgotten, it's not absolute, but we always have to continue to balance the interests, whether it's in our old news media, that, for example, in privacy law, not on data protection, but privacy law, defamation law. If you publish a defamatory article in the New York Times, then again, you have a defense, public interest. But you can't publish everything because we have defamatory or anti-defamatory laws, and we have privacy protection laws that don't only address data protection and digital content, but also the old newspapers. So I think that we are just taking all those interests that were always in our legal systems and try to adjust them to the new world. And I can even give you an example for privacy by design. For example, people whose check bounced. So there's an obligation on the Bank of Israel to publish the names of the people who more than 10 checks of theirs were bouncing. But this information should be out there for only 2 years. Afterwards, these people can go again and do business. So now that this information is digital, is it fair that it will be online? The law says it should be limited to 2 years. So now that, because when this law was legislated, there was no internet. So is it fair that because now we're in the digital age, this information would be online forever? So for example, our authority gave some privacy by design instructions to the Bank of Israel in order to limit the amount of time this data can be traceable. So yes, we always have to do those checks and balances that the technology actually challenges us, but the checks and balances should always be made.
Regarding artificial intelligence, I completely agree that at the moment it's far from the fantasies and from what we see in the movies. But actually your question made me think about a different challenge that we might have when it does improve. I don't know if you saw the movie Ex Machina. Have you seen it? Where there is a very sophisticated artificial intelligence robot that very easily the protagonist in the movie just believes that it's so believable that it's just hard not to treat it as human. And perhaps we might have that challenge one day because of our own bias with things that seem human and how we interpret the world. But at the moment, I agree. At the moment, I don't think that artificial intelligence it's mainly mimicking and repeating and using the right pre-created answers that you gave to questions. And still regarding your question, this is one of the main things that another challenge that I mentioned in the context of social construction of death, and also how we understand bereavement processes today and grieving and how it's supported today. One of the questions that is repeatedly raised regarding these services is whether or not they're going to be comforting or disruptive for grieving processes, because it challenges who has the authority to create the narrative of the deceased person, and also it's very pervasive to your everyday life. So you go on Facebook and maybe you didn't want to remember your deceased grandmother today, but you got an email. But we don't know. And designers that I interviewed, all of them who did tell me about the feedback that they got from recipients of messages, they all described it, except for one case that I heard of a user that committed suicide and sent horrible messages to her family. Other than that one case, all designers, whenever they had feedback from recipients of messages, it was all, do you have more? This was so comforting. So I don't know. It's very new. It's not a big thing yet, and it's hard to know, but maybe it will change practices of grieving. Maybe it will disrupt it, and maybe people won't use it. But it's a very good question.
Okay. Do we have more questions?
So a couple of comments. First, it's quite incredible to hear about websites and services that have a presumption to preserve me or some form of me for 50 or 80 years or whatnot, especially when you marry that with the statistics that we heard in the morning, like lifespan of average lifespan of a website is 18 months.
18 months, yeah.
So these two together, like they don't jive. But thinking about the right to be remembered that way, for me, it's kind of less important, because I hate to break it to you guys, but in 50 or 100 years, nobody's going to care about any of us. About me. Well, you guys, maybe it's going to be different, but it's it's a huge amount of data, and we will be seen the same way as we think about certain personas who lived like 100 years ago. And think about that. It's not that interesting most of the time. But the other comment, on a more serious vein, is actually the right to be remembered, or not the right, but the ability of my digital footprint to be kept. And that's something that kind of bugs me. I don't know if it goes directly to what you talked about, but all the documentation that we created like only 20 years ago lives on floppy disks. Can anyone actually read floppy disks today with all the dissertations that we've written whenever? And that's only 20 years, right? And currently we're talking about data that lives in the cloud. And I'm sure many people here, most of the people here know that there's no cloud, right? It's someone's server. And it really depends on the lifespan of the company maintaining that server, and so on and so forth. Facebook is with us for like, what, 15 years, 14 years, something like that? Even no, 13 years. And that's like, it's just 13 years, right? And it looks like an eternity. So stuff that some people leave in Facebook, is this like a footprint that is going to be maintained? Who's going to be able to read our digital footprint in 30 years? Our grandparents left, written stuff, shoe boxes of photos and whatnot. We can open that. We can look at that. Can you look at my photos from 25 years ago? I submit that you can't. So this is, the flip side of the right to be forgotten, and all the different memory stuff that pertains to keep my personality and memory for a while. But the mere fact of our footprint being so volatile and so like vaporable, if that's a word, that's a big problem that I'm thinking about, and I think it kind of relates to everything being said here.
Thanks. Just wanted to add to that, like the amount of data. I mean, we create so much data, and you say our parents or grandparents left, items. How many of us spend how much time on going through it? And if we are going to leave all this amount of data, think of all the files and all the photos that you saved and you don't go through. Do you want to leave it to somebody else? What they are supposed to do with it? Why do you want to give them the obligation to take care of my mess? They'll have their own and many more.
I would like to comment. I think the right to be forgotten, it's too big to the world, because I think the problem is not 100 years from now. It's 10 years from now. It's 5 years from now. And even if I did something stupid, my child, who is 15 years old now, in 5-10 years might see it on the web, and it's something that I wouldn't like to happen. In 100 years, I agree with you. No one cares, and all the technology will be different and everything else. But the right to be forgotten at the moment, that's a problem, I think.
It's not a question, it's just following up on what Orna said. So we need to make a distinction between the faraway future and the near future and the present, right? And when I'm looking at the examples that Orna showed us, and of course following Sharon's ideas as well, I'm curious, and I'm going back to the idea of Yuval, which you suggested earlier, the idea of regulation. And so in the first panel, when we talked about regulation, we had this sense of like, and I think Paula mentioned it as well, saying that it kind of felt weird to think about regulation when we are talking about freedom of speech, right? And when we talked about privacy, it was pretty obvious that the regulators are trying to do something concerning privacy. But what's happening when we're talking about issues which were raised by Orna, for example? Where is the regulator, and should the regulator have a role in it to begin with? And if so, what should be the criterions according to which the regulator can actually operate? So I'm thinking, when we are talking about regulation, I'm sorry, I come from traditional media industry, right? So I worked several years as a regulator, as Tila also knows. And I remember that every time there was this issue of whether or not to broadcast the content, there was always an issue of like whether the content will be offensive or not. How can we even think about criterions for regulation when we are talking, for example, of videos made by parents of their children, or videos made by teenagers of their peers, right? So I was just curious whether anybody here has some ideas or suggestions or even like thoughts about it.
First of all, with regards to minors, the GDPR specifically says that there is a right to be forgotten and the right to withdraw the consent of yourself, even if you gave a consent as a minor and now you've grown up, and to withdraw from the consent of your parents. For this example, for example. Technology speaking, as I said before, I think that the challenge is that the data has such a long route. So how do you delete it? And maybe the technology world will give you your answers. Maybe we'll have some startups that will be able to follow the data and delete it, because the regulations are very clear. You have the right to be forgotten, especially when you're a minor.
So just to ask you a question about it, suppose I have a child and I put his YouTube video, right, online, and now I can approach YouTube and just ask them to remove it according to the GDPR regulations, right? No questions asked, no extra bureaucracy. Especially when it's a minor. And even if I don't have already, I mean, I don't have the information for my account, I don't have like, so it should make it easier.
Yes, these are technicalities.
Okay.
The GDPR doesn't give an answer for every difficulty.
Okay.
That's the rule.
It's not that easy. It's not that easy because you have to prove that you related to this child. And
by the way, the child has this right as well.
Just something about regulation, and then something about the right to be to erase data or deny access to data. So today in social networks, in some social networks like Instagram, for example, we have some kind of a mechanism for regulating the removal of content. And if the community reports to the network that something is breaches the guidelines of that social network, then the network removes that image, or at least it notifies the user that he or she needs to remove that. So this is one way of addressing it. It's giving power to the people, to the community. I'm not sure that's the best solution. We also remember that Facebook removed the image of the Napalm girl, which because it breached its nudity policy. But is this a good decision making? I'm not sure. So these are examples of kind of self-regulation of Facebook and Instagram, which is also Facebook. And I wanted to say something to kind of to challenge Sharon from a different perspective on the erasure question. Let's talk, for example, about Eyal Golan. For those of you who do not know, he was involved in some kind of a sexual scandal. Now, he is a wealthy man, and he has the resources to hire people, and that's what he did. And they removed all the linking to the kind of inappropriate information about his behavior. So when you Google him, you can find no traces of that information. Now, that's a very wealthy person that has the resources and the will to do so. But not everybody is as wealthy as Eyal Golan. So my question is whether we have some kind of social gap or inequality when it comes to the removal of content or the delinking to content that works for the privileged, for those who can afford for themselves to delink information, where the rest of us will remain shameful and
So first to answer Tal, I think this actually focuses the problem that we really don't have the right to be forgotten in Israel like it is in Europe. Because in Europe it would be very easy. You don't need a lawyer, you just need to go to Google and apply and ask for the removal. If Google denies your request, then maybe it's a bit difficult, but usually you can finish this thing with Google. In Israel, yes, it's very hard because you have to hire professionals that know how to hide the links. And there was never a balance of interest with Eyal Golan. It was just the technology. No one asked the question, is this a public figure? Should this information be online? Now, for those of you who don't know, Eyal Golan is a very famous singer in Israel, and he was under a police investigation because he had sex with minors. Now, he was not charged and he was not indicted because he didn't know that these were minors, or the police couldn't, he was actually asking them if they were minors or not. So on the criminal level, it's a tough question. I mean, he's not a criminal. And there was an investigation and it was closed. And by the way, we have a defamation law. According to our defamation law, once a publication publicizes the fact that you're under investigation, or you were indicted, or you have a verdict against you, then okay, you can go on. But once if the investigation is closed and there are no charges, or if you're acquitted, then you can ask for the removal of the publication, and you can ask for a further clarification. The news outlet should clarify that you were not indicted, or that the case was closed. So in Eyal Golan's case, the problem is that those considerations weren't even taken into account. But in the real world, and if those discussions were made, then maybe it's okay that this information was taken off. And what was your question? Oh, okay, criminal records. Sure. So in the real world, criminal records are limited. There's a limit of time in which the records are kept. And then, there's no access to them anymore, and they have to be deleted, because we have, as a society, an interest for people to rebuild themselves after they were indicted, they served their time, and now we want them to rebuild their lives. So the problem with, actually it was mentioned before in another question, with the verdicts that are online. So that's a problem, and this is something that I know that there are some commissions that are trying to find a technical solution for it. Because the reality today is that according to the law, your criminal records are deleted after a period of time. But then again, this eternal memory actually makes you have to see those verdicts, and everybody knows about them. So I think that the question here is how technology should solve this problem, because the law wants to limit the time in which this data is out and exposed.
In which it is possible to forgive and forget, or do we want to create a society in which we are constantly having to deal with the burden of remembering?
And in criminal offenses, the criminal code gave you the answer. No, there is a period of time in which everyone knows, and afterwards they forget. Okay?
Okay. Yeah, one last question.
To share, this morning we were talking about it, and I mentioned the right to truth and how it has been contrasted to the right to be forgotten. forgotten in my region of the world, especially because dictatorships were there just a couple of years ago, and you had crimes that were considered quite serious and maybe people should not forget, and that's about how you write history and how they try to erase a part of history by passing on amnesty laws and changing history books and all that. So right away there's a huge discussion about that and how to reconcile the right to truth in these parts of the world where you had this type of regimes and the right to be forgotten. So I don't have a solution to that, but I just think it's another issue to bring into the table, and it was quite controversial.
Okay, I would say about this that, again, there's, when we talk about the right to privacy, and the right to be forgotten derives from the right to privacy, we talk about personal data. So with regards to history, first of all, I don't think it's personal. It's not personal data. And if we talk about public figures, then again, we have all those balances, checks and balances in the GDPR and in the guidelines. If it's a public figure, then maybe the data will not be deleted. And there is journalistic and historic interests to preserve the data. And therefore, it's very important that all of those considerations and should be balanced on a case-by-case basis. And this leads me to another problem, because now we know that in the near future, all these decisions will be made by artificial intelligence, not by Google workers, but by robots. So how are they going to do those checks and balances? But that's a...
You don't have strong appreciation of the human kind, right?
Okay. Thank you to all the three of you. I actually have one last question. What I'm interested to hear each of you in your own expertise, and what's your take on the next, let's say, the next decade challenges that we are going to face in this field?
So with the right to be forgotten, I'll give you a European challenge and a global challenge. So the European challenge is more technical, and I just spoken about it. I see two technicalities, which I've already mentioned. One is how can you delete data that was already transferred and copied through numerous controllers. So there should be a technological solution. And again, with the robots, how do we make all those decisions, and how do we balance? I mean, search engines received, I read that Google received 2 million requests to delete data. So I don't know, should Google dedicate all this personnel to this matter? And if not, will robots do this task? And if robots do this task, will it be done properly and correctly? So these are the challenges for Europe. Globally speaking, we have to see who wins, the United States of America or EU, because the right to be forgotten applies to data about EU residents. So there was even a debate with regards to Google.com versus Google Friends, for example, because if for example, the CNIL, which is the French regulator, says, okay, Google, you should delete the content. So what Google did was deleted it via Google France, but the data was still accessible through Google.com. So I think that CNIL issued fines about it, but I don't know if America will accept this right to be forgotten outside of Europe. So the big question of the right to be forgotten is who will prevail. And if I had a slide for this question, then I would put the American, the US flag with eagles on it. So who will win, EU or United States? And that's the interesting question, I think.
I think for there are separate issues. So first, I think that the issue or the problem of accounts of deceased individuals online is becoming a growing problem, and it will continually grow in the next years. because we have more and more users of online communication, because we're going to have a lot more people dying. The generation of the baby boomers are going to be dying. I have a horrible topic, I know. But it's going to be a major issue for many social agents. And so how we manage the data of the dead that does remain online, and how we make people aware of this problem, and how we make people active in doing something about it is going to be a major challenge. And specifically for the transcendence industry and these websites that I'm researching, I think it's this contradiction between what the technology and what the designers are trying to create, and the social construction of death in terms of how we think about the dead, the place they have in society, practices of grief, both are going to be reconfigured until it becomes a practice that is more acceptable.
I believe the biggest challenge ahead is the balance between technology, ethics, that I think we should take ourselves in consider that this is not the right way to deal with things, and merge together. I believe in few years, and I'm going back to the same example of Sharon's, the same student in 10 years, no one will stop her to be a teacher, because she's going to be the manager in 10 years. So we are in the in-between time, which is it's our obligation to think twice before each things we are doing.
Thank you very much.